what if someone is using your name and you never know they're using your name, and you've done a trademark search and there's nothing registered, and you start podcasting with that name, and you're podcasting, and then this person who says they've been using your name sees that you're podcasting and decides to file a claim because they've used that same title for a course they created. So is it different? Like, do you need to trademark something for a course versus trademark something for a podcast? Is it the same trademark? Like, is there a blurry area there? Like, can both exist separately?
It's a really good question. So that brings us to another kind of nuance in trademark law. When a company has a federally registered trademark, it's not like they've got that name on lock for everything. So if I own, I'm trying to think of an example. If I own Ocean is actually my favorite brand for cran raisins, those like cranberry raisin type things. So if I own the trademark Ocean for craisins, it's just for the goods or services that I'm offering. So if someone opens a shoe company and wants to call it Ocean, I can't sue them. I also can't sue Frank Ocean, who's making, music under his own name, Frank Ocean. So when you register a trademark, you have to tell the trademark office which goods and services you're claiming. So in your example, where someone's been using a trademark for a course, and they're trying to stop you from using a trademark for a podcast, on its face, it kind of looks like, well, no, because a course is different from a podcast. But again, that would be the kind of thing that would end up in court, because what they would try to say is, oh, well, courses and podcasts are actually very related. And so this person with the podcast is confusing people. They're confusing my audience. They're confusing my students. So that's a question that I think would be a close call, because courses and podcasts are at least more similar than, say, craisins and shoes.
And you said you wanted to mention one more thing.
I did. And so one thing that small business owners can definitely be on the lookout for right now is trademark squatting. And so one thing people don't realize is that everything filed with the trademark office is public record. And so squatting has become an issue for business owners in a lot of different ways. So first, let's say that you are planning to launch something, but you haven't filed yet. What some people start to do is file for your trademark before you. And then they basically, once they have the registration, they force you to buy it from them. And so people are actually filing for trademarks that they know other people want for the sole purpose of sitting on them and then being like, oh, well, you can have this trademark registration if you want to pay $20,000 for it. So people are sitting on trademark registrations. And so something for small business owners to be aware of is if you're launching something, you might want to be careful who you share the name with before you've actually filed your registration. Now, another place where squatting happens is on domains. So what's also happened to small businesses is they file the registration for the trademark, but that's public record, right? And so you file for, I'm just going to make something up, sexy podcasts. So let's say you file the trademark sexy podcasts. Someone sees that and they immediately buy the domain sexypodcast.com. And the same thing. They're like, oh, you can have this domain for $20,000. So small business owners need to be aware of squatting. And what that basically means is it can be advantageous to get the domain before registering. And like I said before, small business owners might want to be careful who they share their name with before filing that application.